Hello friends, welcome to ePathshala. My name is Malvika Seth and I am an assistant professor at the O.P. Jindal Global University. I will be discussing the module titled What are Economic, Social and Cultural Rights? This module seeks to give students a general introduction to the ECSRs. It will discuss the international and regional instruments that protect these rights, theoretical debates about the legal status and enforceability of the ECSRs, and how these rights are enforced at the domestic level. The economic, social and cultural rights are rights that are aimed at fulfilling material needs such as food, water and shelter, as well as providing access to cultural life of the community. They are broadly recognized and protected in international human treaties, regional human rights treaties, and in the domestic laws of several countries, including India. The expected learning outcomes of the module are as follows. After completing this module, students should know and understand first, the international and regional human rights instruments that protect the economic, social and cultural rights. Second, debates about the status and enforceability of the economic, social and cultural rights. And third, country-specific approaches to enforcing the economic, social and cultural rights. The first part of the module discusses the economic, social and cultural rights in human rights law. The Universal Declaration of Human Rights, or the UDHR of 1948, was the first major international human rights instrument. Though it was merely declaratory and did not have legally binding effect, the UDHR is the foundational document of all human rights law and remains very influential and heavily cited even today. The UDHR gave recognition to a range of economic, social and cultural rights, also known as the ECSRs, which were thereafter codified in legally enforceable treaties. These include the right to social security under Article 22, the right to work under Article 23, the right to an adequate standard of living, including adequate food, clothing, housing, health care and social services under Article 25, the right to education under Article 26, and the right to participate in cultural life of the community under Article 27. In 1966, the UN Commission on Human Rights disseminated 2 human rights covenants that would give legal authority to the rights declared in the UDHR. They are the International Covenant on Civil and Political Rights, that is, the ICCPR, and the International Covenant on Economic, Social and Cultural Rights, that is, the ICESCR, which finally came into force in 1976. They both require formal state ratification. States have to consent to their terms before any binding obligations are imposed. As their titles suggest, the second of these covenants pertains to the ECSRs. Article 2 of the ICESCR sets forth the general obligations of each state party to this covenant. These obligations are broad and make allowances for the differences in development and resources among states. Article 2, Clause 1 establishes that every state party undertakes to take steps individually and through international assistance and cooperation especially economic and technical, to the maximum of its available resources with a view to achieving progressively the full realization of the rights recognized in the present covenant by all appropriate means. Thus, the ICESCR does not require states to fulfill the economic, social and cultural rights of their citizens immediately or even in a specified amount of time. They must simply undertake to take steps towards meeting their obligations under the covenant in the future. The ICESCR also enumerates specific economic, social and cultural rights which correspond closely to the rights in the UDHR. These include the right to work under Article 6, the right to social security under Article 9, the right to an adequate standard of living, which includes adequate food, clothing and housing under Article 11, the right to health under Article 12, the right to education under Article 13, and the right to engage in and benefit from cultural life under Article 15. Regional treaties in the Americas, Africa, and Europe provide additional ESCR protection. In the American region, the two main human rights instruments are the American Declaration on the Rights and Duties of Man of 1948 and the American Convention on Human Rights of 1969. The American Declaration was intended only as a declaratory instrument, while the American Convention is a legally binding instrument. Both recognize certain economic, social and cultural rights. For instance, the American Declaration recognizes the right to health under Article 11, the right to education under Article 12, the right to take part in cultural life under Article 13, and the right to social security under Article 16. The American Convention includes only a right to progressive realization under Article 26, which requires state parties to undertake to adopt measures towards the full realization of economic, social, educational, scientific and cultural standards as set forth in the Organization of American States Charter, that is, the OAS Charter. The additional protocol to the American Convention on Human Rights in the area of economic, social and cultural rights, which is also known as the Protocol of San Salvador, gives legal effect to a full range of socioeconomic rights, including education, health, food and social security. In Africa, the main human rights treaty is the African Charter on Human and People's Rights of 1981. It protects a range of ECSRs, including the right to work under Article 15, the right to health under Article 16 and 18, the right to education under Article 17, and the right to a satisfactory environment under Article 24. In Europe, the principal human rights treaty, that is, the European Convention on Human Rights, does not explicitly recognize the economic, social and cultural rights. The European Social Charter, which was adopted in 1961 and was revised in 1996, however, offers a comprehensive ESCR protection to citizens of the member states. Part 1 of the Charter lists 31 rights and policy aims to be progressively realized. These include various rights of workers, including rights to equal pay, safe and healthy working conditions, and collective bargaining, the right to protection against poverty and social exclusion, and the right to housing. Part 2 of the Charter establishes a range of binding obligations on states, including the right to work, the right to health, and the right to social security. The second part of the module discusses the debates on the status and enforceability of the economic, social, and cultural rights. Economic, social, and cultural rights are often expressed in aspirational language towards progressive realization. This is largely because ESCRs have been traditionally viewed as positive rights, meaning that governments must take positive steps towards fulfilling them. By contrast, civil and political rights are considered negative rights, in that they are fulfilled simply by government inaction. For instance, the right to freedom of speech can be fully upheld if the government refrains from passing laws restricting expression, but the right to food can only be fulfilled if the government affirmatively provides adequate food both in terms of quantity and nutritional content to those who are in need. This dichotomy between positive and negative rights is problematic and has contributed a great deal to the skepticism that accompanies the enforcement of the economic, social, and cultural rights. Under the standard view, positive rights lack the legal force of negative rights. They are often cast as policy directives that do not give rise to legally binding duties and obligations. For example, Article 2 of the ICESCR, which requires states only to take steps to the extent their resources permit towards the full realization of the rights in the covenant. This can be seen in the Constitution of India as well. Part 4 of the Constitution sets forth a range of directive principles of state policy, also known as the DPSPs. The DPSPs are socio-economic aims of the state that cannot be enforced in court. There are two main concerns regarding the enforceability of the ESCRs. First, there is a practical concern that the courts are ill-equipped to handle cases that involve complex questions of resource allocation. Courts generally do not have the resources to undertake their own fact-finding or research and lack the time to adjudicate upon complicated, policy-oriented cases like those involving the economic, social, and cultural rights. Second, judicial enforcement of ESCRs might create separation of powers concerns. Under the standard view, the separation of powers conception, the legislature enacts laws while courts simply interpret those laws. The issue is that if courts adjudicate on ESCRs, they will assume a policy-making or legislative role. The ESCR cases require courts to determine how the state should allocate resources, which implicates a number of policy areas including tax, trade, and immigration. This is arguably undemocratic because legislatures are elected to make laws, which they do through deliberation and compromise, whereas unelected judges issue legal opinions. As discussed, however, both these concerns rely on the assumption that positive and negative rights are distinct and that ESCRs are positive rights. In fact, all human rights have both positive and negative dimensions. Take, for instance, the right to speech. If a state is serious about upholding its obligations under the international human rights law, it must protect speakers of unpopular or controversial views. To do this, it must hire and pay police officers, prosecutors, and judges. The police are required to protect unpopular speakers from violent acts and control crowds in public demonstrations. Judges and prosecutors are necessary to uphold the legal foundations of free speech against both government and private incursions. Thus, a core civil and political right, that is the right to free speech, is not simply upheld by government inaction. A state must invest resources to ensure that this right is fulfilled. Similarly, the economic, social, and cultural rights have negative dimensions. Consider the right to food. To uphold this right, states must do more than simply provide adequate food to those in need. They must also protect each individual's food supplies or access to food from others' interference. For instance, if a farmer grows his own food and a third party destroys his crops, his right to food is infringed. Therefore, states must protect farmers' crops from private acts of destruction. In this context, the right to food is much like a civil and political right. Law enforcement and legal systems are required to protect the food supplies of each citizen, just as they are needed to uphold the right to free speech. The third part of the module discusses the domestic enforcement of the economic, social, and cultural rights. At the domestic level, states have adopted various approaches to enforcing the economic, social, and cultural rights. Some do not recognize these rights in their constitutions, but nonetheless uphold basic commitments to socio-economic justice. The United States, for instance, fits this description. While the US Constitution does not enumerate economic, social, and cultural rights, some aspects of these rights are upheld through ordinary laws and have become part of nations' constitutive commitments. Thus, Americans believe they have a right to social security and to free public education, even though there are no such formal guarantees in the Constitution. The US Supreme Court has upheld these basic commitments to some degree. For instance, it has held that individuals cannot be denied welfare payments without a hearing, as that would violate the right to due process under the 14th Amendment to the US Constitution. The Supreme Court also struck down a Texas law that required undocumented immigrants to pay a tuition fee to attend public school. However, the court has also made clear that the government has no positive obligations to assist those who are in need. It has stated that the Constitution confers no right to affirmative government assistance even where such aid may be necessary to secure life. At the other end of the spectrum, the Indian Constitution has been interpreted to confer a range of enforceable economic, social, and cultural rights. Part 4 of the Constitution sets forth a detailed set of directive principles of state policy, or the DPSPs. These are non-binding guidelines intended to guide elected representatives towards improving socio-economic conditions. Article 37 of the Constitution makes clear that the DPSPs shall not be enforceable by any court. Yet, in a series of judgments beginning in the 1980s, the Indian Supreme Court has held that certain DPSPs are enforceable. One of the most significant cases in this line is Francis Mullin versus Union Territory of Delhi, 1981. The judgment, authored by Justice Bhagwati, extended the right to life and personal liberty under Article 21, which is a judicially enforceable fundamental right in Part 3 of the Constitution, to cover a much broader right to live with dignity. In subsequent cases, the court has held that a number of socio-economic guarantees, which were originally expressed as policy directives in Part 4 of the Constitution, constitute part of a right to live with dignity and are therefore enforceable under Article 21. These include the rights to education, food, healthcare, shelter, and a decent livelihood. The Supreme Court has also devised a number of procedural innovations to ensure that those most in need of the ECR enforcement can have their claims heard. For instance, the Supreme Court has relaxed locus standi, or the standing requirements, to allow any concerned citizen or NGO to bring petitions for the redress of fundamental rights violations on behalf of those who are too disadvantaged to file petitions themselves. It has also adopted a doctrine called the continuing mandamus, which allows it to postpone final judgment in a case so that it may periodically issue guidelines and interim orders to ensure that the government complies with its rulings. These innovations, collectively known as public interest litigation, that is PIL, have greatly expanded the judiciary's ability to adjudicate upon ECSR issues. South Africa has adopted an approach to ESCRs that falls between the minimalism of the US and the robust judicial enforcement of India. The 1996 Constitution of South Africa explicitly sets forth a full scheme of economic, social, and cultural rights. Section 26, for instance, provides, everyone has the right to have adequate access to adequate housing, while Section 27 provides, everyone has the right to have access to healthcare services, sufficient food and water, and social security. Yet, unlike in India, the South African Constitution specifies minimum requirements the state must satisfy in fulfilling these rights. Section 26 Clause 2 and 27 Clause 2 both provide as follows. The state must take reasonable legislative and other measures within its available resources to achieve the progressive realization of this right. The South African Constitutional Court, therefore, upholds ESCRs as full constitutional rights and not merely constitutive commitments or directive principles. But the court limits itself to judging only the reasonableness of the government schemes aimed at fulfilling those rights. As a result, the South African Constitutional Court largely avoids the justiciability concerns which are there with every economic, social, and cultural rights case. It does not involve itself in complex questions of resource allocation, but instead allows the state to craft its own policies that the courts will uphold if reasonable. The Constitutional Court does not go so far as the Indian Supreme Court to devise its own procedural mechanism and remedies. It therefore does not create separation of powers issues. In the end, to summarize, economic, social, and cultural rights are rights aimed at fulfilling certain material needs such as food, water, and shelter, as well as providing access to the cultural life of the community. They are protected at the international, regional, and domestic levels. At the international level, ESCRs were first recognized in the Universal Declaration of Human Rights 1948. These rights received legally binding effect in 1976 when the International Covenant on Economic, Social and Cultural Rights came into force. The Covenant on Economic, Social and Cultural Rights protects a range of economic, social and cultural rights, including the rights to social security, health, education and an adequate standard of living. At the regional level, the ESCRs receive additional protection in the Americas, Africa and Europe. ESCRs are traditionally considered to be positive rights, while civil and political rights have been viewed as negative rights. While this distinction is problematic, it has contributed in large measure to concerns about the legal status and enforceability of the economic, social and cultural rights. These rights are often couched in the language of progressive realization as in Article 2 of the ICESCR and lack immediate legally binding effect. With respect to justiciability, two concerns emerge. First, courts do not have the time or resources to handle ESCR cases because of their complexity and broad policy effects. And second, courts might infringe on the legislative sphere if they engage in policy making, which ESCR cases require them to do. However, once we recognize that the dichotomy between positive and negative rights is flawed, these concerns become less severe. At the domestic level, countries have adopted various approaches to enforce ESCRs. The United States recognizes only minimal commitments to socio-economic justice, which have been upheld by the US Supreme Court to some extent, but it does not appear in the text of the US Constitution. The Indian Constitution includes non-enforceable directive principles of state policy in Part 4. The Indian Supreme Court, however, has held that some of these principles are enforceable through the right to life and personal liberty in Article 21 of the Constitution. It has also crafted a series of procedural innovations known as public interest litigation to expand the scope of its authority in enforcing the ESCRs. Meanwhile, South Africa's constitution sets forth enforceable ESCRs, including the rights to adequate food and shelter. The constitution also establishes the standard of review that governs the case's reasonableness. Therefore, while the South African Constitutional Court is empowered to decide on ESCR cases, it is limited to judging whether the government schemes are reasonable and may not craft its own procedures or remedies. With this discussion, I hope you have been able to understand the economic, social and cultural rights. For further learning, you are requested to refer to the e-text and self-assessment resources. Thank you for listening.